So, as the topic is given to me today is on the in our national webinar perspectives 2020 child protection, child rights, laws, policies and system. Within a given time, very vast area, each one topic also required maybe very lengthy discussion, but let me see that how much it is possible I can able to give some outline or some of the salient features on these areas. So I am Dr. Rangasami, Chairperson, Department of Social Work from Amrita, Viswa, Coimbatore. So when we discuss about the children, in the beginning, Mr. Leiju was mentioning about the who is a child. And as now, most of us all, now we have all grown up people. So once we cross these 18 or 19, 20 years, so we completely or almost we don't want to remember. So what has happened for all of us in the past? So what was our situation during our childhood? Where did we study? Where did we born? Where is our where was our hometown, village, our schoolmates, teachers? So we forget because we enter into the mainstream of social life. As after 18 or 20 years, we forget. That is the reality in our country. But when we see that, when we consider throughout the civilizations, as that the all civilizations we have that the children did not consider as a separate category, as a separate person or human beings. They are all set aside. They are not are involved in any major activities or some kind of importance given in their civilizations. In addition to that, there was no independent social category till the 18th century, and no special legislations till 19th century also. In this process, so what has happened is that father has had the absolute right over children. In our families, we can see, even now we can see that. So father has the ultimate control, power and authority. So all our activities, all our work, management of family affairs and our relationship, network, food, accommodation, health, everything will be looked after only by father. That was the father, that was the position. What happened is that this position, this area is known as the welfare principle. See, when we talk about the welfare principle, based on the welfare principle, so he tried to that he is being himself as a self-disciplined person. He sacrificed for his family, children, and the consideration for others. So that was the hallmark, that was the salient features of the welfare principle. When we say that the welfare principle as a father has is that or himself is dedicating, committing, self-sacrifice in all these areas, so he will look after all these family members. That is known as the welfare principles. In these welfare principles, if you see that when we try to move on to the history, in the status of children, so we have that now more than 1/3 of the population below 18 years. India has the largest young population in the world. 1 out of 16 children die before they attain the age of 1, and 1 out of 11 die before they are 5 years. 35% of the developing world's low birth weight babies are born in India. So 40% of the child malnutrition in developing world is in India. The declining number of girls in the age group of 0 to 6 years age group is a cause of alarm for our policymakers and government and voluntary organizations. For every 1,000 boys, there are only 927 females. Even some areas, some districts, some villages, less than those figures. So that is the condition. In addition to that, we have out of every 100 children, 19 continue to be out of the school. So only the remaining go to school. Of every 100 children who enroll, 70 drop out of their time they reach the secondary level of education. Of every 100 children who drop out of the school, 66 are girls. And 65% of the girls in India are married by the age of 18 years and become mothers soon after, immediately after their marriage. India is home to the highest number of child laborers in the world. So India has the world's largest number of sexually abused children, with a child below 16 years is raped every 150 minute. A child below is 10 every 13 hour, and at least 1 in every 10 children sexually abused at any point in time. So these are some of the statistics related to children we have in this process. So what has happened is that the father has the absolute right over children and family members. From the right-based approach to that, these are known as from welfare to moving to right-based approach. When we say that welfare-based approach is that there is no entitlement, or there is no condition, or there is no compulsion on the part of the caregivers. Either it may be family members, or it may be government institutions, or it may be a kith and kin of the children. So it is automatically the child is that are getting any type of service is basically of the will of the caregivers. But when we are moving from the welfare approach to right-based approach, the concept of children in 20th century has completely changed. From this change, what we mean is that now welfare to right more approach. When we talk about a right-based approach, rights, children's rights, so it is basically that it is the caregivers, the policy makers, and the stakeholders and the government. So they have to fulfill the what are the basic rights: the food, accommodation, education, the environment. The children has the right to demand. Earlier in the area of welfare area, the children did not have that any rights over there. All these rights, all these provisions, because it is a welfare aspect. But when we say that children has a right and the rightful entitlement, and in this rightful entitlement, the people are the policy makers, the government, and the caregivers, who are all the supposed to be care for the children. They should look after these children. They have to fulfill these all the basic requirement. So otherwise, it will be considered as a violation of child rights. So when we talk about the child rights, the right-based approach, what it talks about, what it means, what it is indicate is that it is fulfilling the social justice, it is fulfilling that non-discrimination aspect, and equity and empowerment. So all these things are integrated, empowered, united, and converged in these areas of child rights. So in this background, so when we see these, the emergence of UNCRC. So when we see the emergence of UNCRC, so on the evolution of the child rights in India, we have that, we are all familiar with that, the November 20th, 1989, the UN General Assembly adopted the Convention on the Rights of the Child. That it is commonly known as the UNCRC. And on 26th, 1990, on opening day of the session, 61 countries have signed it. Under the CRC, the Convention on the Rights of the Child covers all children under the age of 18 years, regardless of their sex, color, and language, religion, or race. What happens is that any child who has not completed the 18 years of the age will come under the purview of the child as a category. So in this process, the government of India also ratified the UNCRC in the year 92. Since then, government has enacted several legislations and several taken welfare programs, policies for fulfilling what was the content, what was the salient features of the UNCRC. India is implementing in various legislations in our country. So in this, see that what is the major area of that UNCRC is mentioning about that, and in the opening remarks also our chairperson has mentioned about the about children's rights. So that the UNCRC has are commonly as categorized four different type of child rights. One is that survival, second is the development, third is the participation and protection. In the survival right, that what is the basic survival right the child has to this, that as soon as the child is born, the child need to be given that immunization and proper food, accommodation, and that for all type of the social security measures for which require for that child to survive. Is a child to survive that in a family environment, food, proper accommodation, immunization, protection. So all these things are essential, that then only the child will grow in a good environment. It is not merely that survival, that it is not merely that they are telling about the things. That as soon as the child is born, what is the basic requirement that need to be provided? And moving from that survival to that the development. So what will happen is that the child is to have that good environment or play environment, proper school, proper education, proper or association with the neighborhood. It is that another important aspect which has mentioned in the UNCRC. And another important thing which we have, that participation. The child need to be it is not merely participating or merely having a number in that in our society. It's not having a particular association. It is the meaningful participation, involvement, that in a group which they like. The child which is need to that the group's participation, which encourages the child's the survival, further development, further prosperity, further live in a very good environment. So all these the things are very essential in the participating environment. So survival and development and the participation, all these things that need to be taken into another area is that protection. It is the protection is the very is the highest form of the child which required. So we have seen that a large number of that lot of statistics which is revealing about the situation or condition of children in our country now. So each and every child born in our country, in our families, in our neighborhood, in our community, they should have a safe and secure environment. The protection from that the all forms of exploitation, all forms of abuse, all forms of maltreatment, from all forms of that disturbances, that the child need to be protected. So then only that the child will have a better peaceful life in that area. So these are some of the four different type of the rights or categories of child rights, which is mentioned in the UNCRC. With this, so the government of India also has constitutional provisions which provided, which is mentioned in the in our constitution. Among them, that there are I will mention a few about what are the constitutional provisions which talks about the child rights. So Article 15 affirms the right of the state to make special provisions for women and children. Article 24 provides that no child below the age of 14 shall be employed in any form of work. And also we have enacted a legislation in this regard. Article 39E also was mentioned about the didactic principles of state policy, which provides that children of tender age should not be abused and should not be forced to economic necessity to enter into vacation unsuited to their age and strength. Article 39F also requires the children to be given opportunities and facilities to develop in a healthy manner and the conditions for freedom and dignity, and the childhood and the youth to be protected against exploitation and moral and material abandonment. And Article 45 of the Didactic Principles of State Policy provides for free and compulsory education for all children until they complete the age of 14 years. So we have also a special legislation in this regard. So these are some of the provisions in our Indian Constitution provides constitutional safeguards, constitutional provisions, which has that in the form of our articles, and also which also in the form of the directive principles of state policy, which is also the motivate and encourages and insists the state governments to look after the children and women, their programs and policies. So in this regard, so we have that moving to another area is that the vulnerable children and the need for care and protection. So as we have seen that from the 16th and 17th century, the categories of children and people who are all involved, father has the absolute authority and power and responsibility. From the welfare mode to that we are moving to that and right-based approach. From the right-based approach, we have the UN CRC, and from the UN CRC that we see that rights of the children. From the same way also that the Government of India ratified. After the ratification, we have the government, the Indian constitutional provisions which safeguarding the children. So in spite of all these best efforts, protection, participation and involvement, we have that India is a vast country, as we have seen that about 40% of the children are below or the 18 years in our country. We have seen that. So children in our country, we have seen that it is a heterogeneous group. It is a totally heterogeneous group. In this heterogeneous group, we have seen that children are we have that different type of children, and different children are put into a different type of vulnerable situation and vulnerable conditions, and which need to be that the government has to look after the various needs and the requirement of the children. So among the hetero group of children, we have the children with homeless children, like payment dwellers and displaced and evicted, refugees and migrant children, orphaned and abandoned and destitute children. We have the children whose parents cannot or not able to take care of their children due to their illness or sickness. And street and working children, we have that another category. Child beggars, victims of child marriage, trafficking children, child prostitutes, children of prostitutes, children of prisoners, children affected by conflict and civil strife, children affected by disasters and both natural and man-made, children affected under substance abuse, and children with HIV and AIDS and other terminal diseases. We have disabled children, children belonging to the ethnic and religious minorities and other socially and economically marginalized communities and groups, jail children, and the unborn child, children in conflict with law, those who are committed a crime, children who are victims of a crime. So all these the categories, groups, you can see that these type of children, these type of children are there in our communities, in our cities and in our urban areas, and each and every category of children, their basic needs and requirements are different. Each, as I just said in the beginning, so these children, it's a very highly heterogeneous group. each categories, each groups, each communities, their basic needs, basic requirements, and we have to look after the different type of services we have to provide them. So then only these children can be put into a normal environment. So we have to do a lot of the service activities in a planned manner, so that these children's vulnerability can be reduced. So otherwise, what will happen is that if you don't address these children's, these subgroups vulnerability factors in a timely manner, in a positive manner, in a positive environment, so that what will happen is that if you don't address them in an appropriate time, in a situation, there will be in a more risky environment, and there after some time they will be out of reach in our any type of service activities. So in this regard, so we have that. So how to tackle, how to address, how to look after these services, how to manage these kind of programs. So one type of the addressing these issues, we have the different type of legislations, different type of programs, different type of act, rules and regulations. Yeah, there are the several type of the legislations we have that. Some of the legislations I can show that here, that like protection of children from sexual offences, and then we have the legal and framework for children, Child Labor Prohibition Act, and the Juvenile Justice Care and Protection Act on 2015, and we have the laws related to that rights of the children to free and compulsory education act 2009, and we have the prenatal and diagnostic technique act, and we have the information technology act, person with disabilities act, transplantation of human organ act, infant milk and substitute act, and we have the scheduled caste and scheduled tribe prevention atrocities act, and we have the bonded labor system abolition act, we have that 1976, national policy for children, and that ITP act, immoral traffic and prevention act 1986, and factories act and 1949. Like this, we have there are several laws and legislations and rules which is we have that Government of India enacted, and through these legislations we try to reduce the vulnerability of children in our country. In this regard, if you see that there are several legislations, we have seen that there are more than 20-25 legislations we have exclusively related to children. So among them, that we have that there are 4 important legislations we have that. So 4 important these legislations which we cover. So we will discuss little more elaborately is that Juvenile Justice Care and Protection Act 2015, and the Protection of Children from Sexual Offences Act on 2012, and we have that protection of the Child Marriage Act and also Child Labor Act. These are the 4 important legislations that which has that more number of cases and more number of incidents are affecting on under these legislations. So if you see the Juvenile Justice Care and Protection Act, so 2015, it's a very comprehensive legislation. It's a comprehensive legislation in the sense that so it has that it has mentioned in this preamble that why this act has enacted, and what is the conditions, what is the importance of this act, and who are all the responsibilities of the authorities who are mentioned in this act, like a Juvenile Justice Board and also Child Welfare Committee, and what is their role and importance, and what is that the role of these members and this board, and while having the children under their custody, and we have a transfer approach is also there, and we have a large number of child care institutions across the country. If you see that now in Tamil Nadu and Kerala has the more than 50-60% of the child care institutions in our country, and how to that the control, how to monitor, how to the provide the adequate the guidelines for this management of these child care institutions, not only management of the child care institutions and also the inmates, children, those who are residing, living in this child care institutions should have a proper care and protection and education. That's also mentioned in this one of the salient features of this legislation. And another important aspect is that rehabilitation and reintegration of services of the child care institutions is also mentioned in this Juvenile Justice Act. And we have the another important aspect we have mentioned about the adoption authorities and the District Child Protection Unit and the SCPS authorities have mentioned in this legislation. And another very important, the provisions have included in the offenses against children. So far that any offense committed against children, there was that the police authorities and who have invoking the provisions of the Indian Penal Code provisions. Under this Act, Juvenile Justice Care and Protection Act, that there are 11 the offenses has been classified, and also the punishment also has been indicated in that in this legislation. And for another important aspect, we have that monitoring mechanism of this legislation. So we have the state authorities like that, the State Commission for Protection of Child Rights, and also we have the National Commission for Protection of the Child Rights, are the authorities who monitor that how this act is being implemented across the country. Like this, different type of mechanisms are involved in this very important piece of legislations. So when we see these legislations, the Juvenile Justice Care and Protection Act. So under this act, the children have been broadly categorized into two groups. So children have been broadly into two groups. One is that children in conflict with law. And another type of the children, we have also the children in need of care and protection. So the law that divides the children into two categories. And also there is another one more small group of the children in contact with law also they have mentioned. So when we see that, what do you mean by the children in conflict with the law? As per the JJ Act is that any child, as per the Juvenile Justice Care and Protection Act is that any child means that a child below the age of 18 years. So any child that who has violation, the violation means that the violating the any that provisions that the sections of the Indian Penal Code. So any child that violates, so what will happen is that the police authorities will apprehend. So when we say that the police here, that the salient feature of this legislation is that it is not in a punitive sense. It is basically the rehabilitation and the reintegration of children into the society and to make them useful and responsible citizens of this legislation. So when the police authorities, not only the police authorities and the judiciary and also the Child Welfare Committee and the Juvenile Justice Board, the lawyers and the caregivers, anyone who is the part of the legislation, they must see that the children who are all come under the category or come under the purview of this JJ Act must look into that child as to make them as a useful child, and also the rehabilitation and reintegration of the child. The child may be that it will come to them in any form. It is that the child may be a robber, he may be a theft, he may be you have involved in any type of a serious offense. But irrespective of all these things, that taking into that child's background, situation, and his family background, his economic background, so all these things taking into consideration, the people, those who are the stakeholders must, and the caregivers and the duty bearers must provide a type of service. That type of service, and it is known as it is the reintegration and also rehabilitation of the child. As I said, the law divides the children into two categories. As that we have that children in conflict with the law. The children in conflict with the law who has committed an offense. So when the police apprehend, so what will happen is that you have to look up into the child. As soon as they apprehend, they have to produce the child before the Juvenile Justice Board after fulfilling the basic requirement. So what is the basic requirement is that the person, that the police officer who apprehend the child, immediately they have to inform the parents of the child. That is that if the child is that or the after apprehension, so they have to verify that whether the child has below 18 years. So if the child is only below the 18 years, they will see that the school certificate or the birth certificate, and after fulfilling that, if the police officers they satisfy the child is below 18 years, then they have the authority to bring the child to produce before the Juvenile Justice Board, which has been it is a semi-judicial body. It's the regular magistrate and two social worker members are the members which constitute the Juvenile Justice Board. It is a semi-judicial authority, so they will deal the cases related to the children. Any child who has committed any offense before they completing the 18 years of age, they will not go to the regular court. The police should not take the children to the regular court, because the offenses committed by children, if the child is below 18 years, they have to bring the child to the Juvenile Justice Board also. Now it is functioning in all the Friday, Monday to Friday, all these days it is functioning. So when the police officer apprehend the child, that when the board is not sitting, that they can produce the child before any member of the Juvenile Justice Board, and later they can be ratified. So that once the child is apprehended, the child has every right. The child has the right to her bail. So that they can approach that the proper advocates that the child can be get released. Suppose the child could not be released on bail because the child has committed a serious offense, and what will happen is that the child will be put into the observation home by the Juvenile Justice Board. So the board will recommend the child to be placed into the observation home till the child get released on bail. There are situations the children cannot be released on bail, or that the children may be required for a longer period, or specialized type of training is required. The child may be transferred to that or a special homes in the particular state. In a state, we can have that one or two special homes also will be there in each state. So this is the system is functioning that across the country. We have the Juvenile Justice Board, and we have the observation home, and also we have the special home. So these children who are in conflict with the law will come under these categories. Another categories of children, we have the children need of care and protection. So these children are entirely different from the children in conflict with the law. The first category of children who have committed an offense, but the children in need of care and protection, they have not committed any offense. But why they are called as a children in need of care and protection is that who are they first? There are some situations they want to that the children in villages and rural environment, they want to see the city environment, or there may be some abuse happened at home, or that the parents quarreling and fighting each other. Child may not like the situation, or sometimes the parents may scold or beat the child for getting lesser mark in their academic subjects. All these situations, what will happen? A group of children or individually, children may travel from their native place to work, looking into running away from home environment. So when the children come to that cities, in railway stations and bus stands, they don't know where to go that further. In such a situation that children are apprehended again by the police or any person, then they will produce the child did not commit any offense, like children in conflict with law. The child committed only the mistake is that, but due to some the situation which is not conducive to the child at family and home environment, run away from home. That is the only the child has committed a small or we can't say it's a mistake. It is due to some pressure environment. The child has come out of from the family environment. So in this situation, any person or any police officer see the child, then they have to produce before the child welfare committee. So the child welfare committee is a committee under 5 members, 1 chairperson and 4 members. So they are expert in that area of the counseling, social service, social work, and the child psychology, psychiatrist. So with this experience, these people are the committee members are appointed. They will they will discuss with the child, and if the child is very close to the family environment, immediately they will send them home. And suppose the child is far away place, the child will be sent to the children's home and reception unit for a shorter period of time. So during this time that authorities will try to trace out the child's the local guardians and also the parents, and will inform them, and they will take them to they will hand over the child with the proper advice and proper counseling. So these are the 2 different type of children basically, as the Juvenile Justice Act is mentioned. And one more category of children we have, that the children are in contact with law. There are situations the children can be or involved as a witness. The child may have seen that some robbery or some kind of murder, some kind of or domestic fight. In such a situation, the children will also be involved, brought in as a witness. That is known as some children. That is known as the children in contact with the law. They have to say that nothing more than that. They have seen, they have approached, or they have as a witness, they will give their opinion before the court of law. So that is the type of children we have, that we have mentioned in the Juvenile Justice Act. So the another important aspect the Juvenile Justice Act has provided for authorities is that offenses against children. That earlier, so any person that has committed any offense against a child, so what will happen is that the police authorities, law will look after only the IPC provisions. But now we have the as per the Juvenile Justice Child Protection Act, the section 74 onwards, we have the till 84, the 10 sections which deals about any person, any individual, any group has committed any offense against the children, they will be punished as per the provisions of this the JJ Act. There are some important provisions we have mentioned is when we say that child is involved in any type of offense or committed a crime, someone is mentioning, giving in the newspaper or TV, some social media, it is a serious offense for which that 6 months imprisonment with fine will be imposed, and cruelty inflicted upon a child by a person having the actual charge. When the family environment, in a institutional care or in a hostile environment, if anyone is or trying to or damage or trying to give or they try to act like in a cruel manner, it is a serious offense. 3 years imprisonment will be provided. Employing for child for begging, 5 years imprisonment. Intoxicating liquor or narcotic drug to a child, 7 years imprisonment. Using the child for vending or peddling or carrying any intoxicating liquor or drugs is another 7 years imprisonment. Exploitation of child to employ in his organization, 5 years imprisonment. Offering adoption without following the provisions of the provisions of the adoption procedures. Selling or buying of a child, 5 years imprisonment. Beating a child, corporal punishment, a fine of 10,000 will be imposed. Use of child by militant groups or other adults, 7 years imprisonment. kidnapping or abduction of children, punishment as prescribed under the section 356 of the Act. So all these the provisions have been incorporated in the 2015 Act of Juvenile Justice Care and Protection Act. So if you see that there are the protective mechanisms or measures are available as per the JJ Act. So then another important legislation we have that the legislation we call that the Protection of Children from Sexual Offences Act. So before going to that act, if you see the child abuse cases in our country, so we have that several the cases are in our newspapers and media we have come across. So these are the figures on which have mentioned in the Ministry of Women and Child Development website, and their report indicates that so 53.22% of children reported by sexually abused by that known people. Among them, 50% of abused by people who they knew or were held in a position of the trust and responsibility. It may be a family environment or in a educational institutions or childcare institutions. 150 million girls and 70 million boys witnessed forced sexual intercourse or other forms of violence involving physical contact. It's a UNICEF report. So these are the reports we have seen that. These are the government of India report which has discussed, talks about some of the facts about the child abuse and child maltreatment, child exploitation situations as per the government reports. So in this regard, so what happened is then how to punish them, so how to control them, how to rehabilitate them, these kind of situations. So what happened is that so we have the protection of children from sexual abuse or in different dimensions, different areas. But what happened is that if any child is abused by any family member or any other person, but no law in India till 2011, no law was there. Law on the protection of children from sexual offences passed in 2012, and so what happened was that the child abuse cases were booked under the weak sections of the Indian Penal Code. As we have seen that before 2012, if a child is abused, so what was the situation is that the police authorities will invoke the provisions of the Indian Penal Code. We don't have any separate legislation, separate law to punish those offenders. And another important thing is that the onus of proof is on the part of the victim, that the victim has to say that go to the court and before the magistrate and say that the so and so that has treated badly or abused badly, something like that, has to say that he has to prove that now the abuser till that the abuser or the perpetrator is free, that he not to prove that his innocence need to be proved. But as per the act of the 2012, that the onus of proof or burden of the proof is transferred from the victim to that the perpetrator. That is one of the salient features of this Protection of Children from Sexual Offences Act. So in this act, that where we have that, as I told you that earlier, the IPC provisions did not distinguish between the children and the adult till 2012. Even now, that provisions that we have the IPC Indian Penal Code provisions are that they follow the same the procedures and provisions will apply for the adult as well as children. So in this background, so the government of India enacted a legislation called that the Protection of Children from Sexual Offences Act. So there are the 5 different type of offences has been classified as per this important legislation. One is that premeditated sexual offences assault, which means that the offense, the punishment will go to that imprisonment for a period of not less than 7 years, but can extend for lifetime and fine also. Penetrative sexual assault, aggravated penetrative sexual assault. The person who is the aggravated penetrative sexual assault means that the children who are somebody's control or authority, some institutional care, police officers, and also the children in under the custody of the temple authorities, or with the government authorities, government institutions like this. So those people, those who are in authorities, commit this offense. What will happen is that it's a rigorous imprisonment for a term not less than 10 years. Which means that the penetrative sexual assault, the common people commit that 7 years, but the people, those who are in authorities, commit that this same type of offense, the punishment will be not less than 10 years. Another important offense is that sexual assault, imprisonment for a term not less than 3 years, which may extend 5 years also. Sexual assault, aggravated sexual assault, imprisonment for not less than 5 years, that may extend 7 years and above. Then sexual harassment, imprisonment up to 3 years. When we are talking about the sexual harassment, what will happen is that when even making a small sound on the either part of the or on child, either a boy or girl, or giving your hands, or giving some kind of noise, or showing a mobile phone, or giving some kind of signal, any form, even without uttering a single word, if any person commit any offense like this, even waving a hand towards a child below 18 years, it will be considered as a sexual harassment. You not commit any offense, you say anything, but even looking at the children and disturbing them, waving hands, giving some signals, showing some mobile phone or books, whatever it may be the form, right, giving some kind of noise sounds, which will automatically will involve is a sexual harassment. So that these are the provisions, very important and silent provisions, which have been included in the Sexual Offences Act of Children 2012. So in this background, when we see that, so we have the next area. So we have seen that juvenile justice care and protection, how the children are protected in various forms of exploitation, and we have exclusive legislation how that protect the children from sexual exploitation. In this background, so we have the child protection system also very large, very huge in our country. So what happened is that now from the Supreme Court to that till the lowest level of the village child protection community level, country has enormously has a very important, very solid, very powerful child protection system is functioning in our country. You see from the Supreme Court Committee on Juvenile Justice, we have that. So under this, we have that each at national level, under the each state level, we have the High Court Committee on the Juvenile Justice. How that the system is functioning. At the High Court level, there is a separate committee which is known as the Juvenile Justice Committee of a High Court. In each state, it is functioning. They will monitor the child protection system, how it is functioning, how it is being implemented. So under this system, so what will happen is that at the national level, we have the National and the State Commission for Protection of Child Rights. So we have that these commissions, and the National Commission for Child Rights, Delhi, and also the counterpart here is the state level. We have the State Commission for Protection of Child Rights in each state. We have that. As we have seen that some of the important legislations which we have that the Child Marriage Prohibition, Prevention of Child Marriage Act, and the Child Labor Prohibition Act we have, and the Juvenile Justice Act, and also Protection of Children from Sexual Offences Act. So all these acts that are major the offences have been committed under this act only, and so these act provisions only invoked to protect the children in our country. So under this system, we have that Ministry of Women and Child Development, And a child under state level, we have the State Commission for Protection of Child Protection Society. So we have that the district level, we have the District Child Protection Society, we have, under which we have the District Child Protection Unit, which we have under each unit, and we have the district level child protection unit. We have this 10 to 12 member team in each district has been established and functioning effectively. Under this act, we have that under this district child protection unit, we have the district level and the block level villages, healthcare provisions, education of system, child development of Anganwadi workers. We have that police and the local child line authorities, and the NGOs are and working for them, and which are included child care institutions, non-residential child care institutions, and legal services. So all these major areas, the district child protection unit, which has a liaising and networking with them. So we have the very powerful, very strong in each and every district. So this mechanism is already functioning, and they are integrating, they are converging, they are liaising to protect the children in our environment. With this, we have that at the child line at national level is functioning with under the Ministry of Women and Child Development. At the district level, the child protection committee, and we have that the block child protection committee and village protection child protection committee. So these are the some of the committees also which is included functioning at the grassroots level, district level. District level we have the village level, and the block level we have the committees, district child protection unit, state level state child protection unit, and the national child protection units and the commissions. So all these are the in a well established, well timely manner. They are functioning and fulfilling the and protecting the children in various aspects. And the system, we have also the one of the important aspect, we have the adoption process. So as per the JJ Act, the adoptions also has been given important provisions to look after the giving adoption. These activities have been streamlined as per the system of the adoption process. There is a well established system. The Central Adoption Resource Agency has been given the legal provisions, and they will be implementing the adoption process in a under legal environment. So from, if you see the child protection system in India, from the level of the Supreme Court to till the level of village child protection committee level, so there is an effective system is functioning, and the authorities have been established, and their duties and the responsibilities have been created in a very effective manner. So for which we should have a provisions. So what is the provision? Where it is mentioned? What is the schemes we have that? So we have that the integrated child protection scheme. So that 2012. So we have the scheme of integrated child protection scheme. In that scheme, so all these the authorities, semi-authorities, their responsibilities and the duties, and everything has been thoroughly mentioned in a detailed manner. So the schemes or the salient features are very systematically enforced or systematically implemented by all these authorities, and monitored by the commissions and the other higher level bodies. So these are some of the protective mechanisms we have for children in our country. So from the beginning, as we have seen that what are the some of the just to have a recap from our earlier discussion, from the some 45-50 minutes, from the about the rights of the children, and we have that the father has absolute power and authority, from welfare mode to rights mode, the emergence of UNCRC and the government of India's provisions. Before that, we have seen that categories of different categories of children, survival, development, participation, and protection. So, government of India's the Indian constitutional provisions, we have seen that, and we have the children with various type of vulnerability and vulnerable situations, and who are they, how are they, and what is their requirement in a heterogeneous environment. Each and every segment is different. Government has a policy and programs. So government and policies and programs are in the form of different type of legislative mechanisms being are monitored. To monitor these legislations, we have that now 4 important legislations. Also, we have seen that among the 4 important legislations, we have seen the Juvenile Justice Act, Protection of Children from Sexual Offences Act, and the Child Labor Act, and the Prevention of Child Marriage Act. These are the 4 important legislations which has the provisions which look after the children, protect the children in a safe and secure environment. So when we see that these type of the child rights and child protection laws and legislations programs, and it is each and every one of our responsibility that so child care and child protection is not a very easy thing that and it is that are each and every one of our responsibility to involve whatever the small way we can contribute, and we can rehabilitate, we can reintegrate this type of children in our society, in a social environment, so that the children can be are placed in a better environment in future, and they can grow and they can contribute for our national development. So I thank you very much for the ATMA Foundation for giving an opportunity to share some of my thoughts in this area in a given time of 1 hour, something like that. So thank you very much. Over.